Good morning, everyone. Hope everyone is doing well. My name is Jenn Truong, and am excited to talk to you about the latest in Washington workers' compensation and give you some considerations moving forward. So first, I think you might have heard the Department of Labor and Industries is proposing 2026 rate increases. This is probably going to be about 4.9% increase. And of course, it's to cover the higher cost of benefits and adjudication of these workers' compensation claims and the benefits that these workers get when they're injured. And so the increased cost is about $1.37 a week per full-time employee on average. And so this breaks down 75% the employers pay, and then 25% is what the worker pays. And so when we're looking into 2026, think about budgeting, think about how this might impact. We know that your safety and health record and your workers' compensation history impacts your experience modification rate. So now is a good time. Safety and health, this could be its own presentation on its own, but look at what are the common hazards in your workplace. What can you do to communicate the safety expectations, the rules, communicate those, um, you know, discipline, document so that you can prevent those injuries from happening. And if they do happen and you get investigated on site, you'll have an opportunity for defense. From the workers' compensation end, I would say take a look at those claims that are initially filed. Is there room for challenging that allowance via protest? And then for the claims that you do have, maybe taking a look at how, if there's opportunities to be more aggressive about closing those down. And good faith and fair dealing. So our legislature has passed the SB 5463, and this will be effective January 1st of 2026. So it broadens the duties to the self-insured employers and TPAs. Earlier, the House bill covered employers from the self-insured employers for workers within municipalities and firefighters, but now it applies to all self-insured employers and their TPAs. And so it applies to all aspects of the workers' compensation laws. We need equal consideration for the workers' interests, and a violation is going to be found if a worker is coerced to accept less than compensation due under the law. So a key aspect of this, for example, will be your settlement agreements, taking a closer look at that. In department actions, there was a lot, I'm sorry, of back and forth on this. And so the department will be the one charged to investigate any alleged violation of good faith and fair dealing. They'll investigate, issue an order. If they have findings with the order, the penalties can be 1 to 52 times the average weekly wage at the time of the order with accrual. So this is going to have consequences. And there was a lot of discussion about decertification. So if there is a violation 3 times in a 3-year period, the director must impose a corrective action plan, which includes probation. It provides self-insured employer restrictions, and then there will be audits to ensure compliance. And then only after those steps are followed can the department withdraw the employer's self-insurance certification if further violations occur. So considerations moving forward. Review internal claims handling practices for compliance and fairness. Train claim handlers on what good faith and fair dealing means in practice. Communication is key for self-insured and state employers, right? So clear, timely communication with workers about their rights, obligations, and benefit status. Self-audit. Identify gray areas where policy and updates or retraining may be needed, and make sure that we're reviewing all of that. And of course, monitor for continued updates from the department as this rolls out. And the department's third-party recording pilot extended. Okay, what does this mean? Why does it matter? So for context, we know that the medical opinions drive workers' compensation claims. And so the worker is able to go to their attending physician, go to different specialists, go to the emergency room to get medical opinions. But workers really rely on independent medical examination. So if we rewind back in July 23rd of 2023, there was a House bill that passed, amended an RCW, and it allowed the worker to record the examinations. However, it didn't touch on the ability of the doctor on the panel to record or the employer's ability to record. Um, with that said, it also provided the claimant the opportunity to assert their intent to record within 7 days. And so if the doctor found out that within 7 days the worker was intending to record, they didn't feel comfortable. That combined with the notice requirements for setting IMEs, it just really delayed the adjudication process. So the department heard everyone's concerns, they took the feedback, and so they are using a third party company called Medical Memory. And it's really a third party recording company that is hopefully giving tools to everybody involved to feel more comfortable. It is voluntary for the claimants, they can still co-record, but it's HIPAA compliant. It takes away the logistics, and the department is hoping that that will work to avoid the delays that we had that we mentioned. So employer considerations moving forward, continue to send the department feedback. I think that they're listening. Always review the timelines associated with the IMEs for notice. Timely kind of address any objections. From my personal observations, I do think the IME panel companies are doing a great job of educating their doctors or enlisting other doctors that feel more comfortable being unilaterally recorded. So I've heard from the self-insured employers that they seem like there's more options for IME panel doctors. And ending our time together, I wanted to point out that the board has a tentative significant decision, so pending final input and revision prior to formal adoption, but I thought it was interesting. It's In re Sabine Miranda. It's an April 2025 case, which clarifies when a worker is considered an employee under workers' compensation. So in this case, the worker had a right knee injury that occurred during a pre-employment agility test. And so the board determined that the claim should be denied as the worker was found not yet an employee. So I would, as an employer, take away these considerations, right? So the board relied on a two-prong factor test to determine whether an employment relationship existed. And so this was based upon a 1979 Washington Supreme Court case and also a Court of Appeals Division 1 2014 case. And the test looks at whether employers have the right to control the employee's physical conduct and performance of their duties, and also whether there was mutual consent to an employment relationship. So the takeaways, if your company engages in pre-employment physical testing processes, keep these factors in mind. Usage of a third-party testing company that was completely off-site, that the employer did not have control of, seemed to be a factor in this one. Train HR and safety teams to understand the boundaries of coverage. And I also wanted to emphasize again that this tentative significant decision did not address the course of employment.